The custody designations through the based-in or the rabbinical agreement process are going to mirror the terminology associated with a secular divorce. In other words, there's going to be joint legal custody or sole legal custody. There's going to be a parent of primary residence, a parent of alternate residence, and there's going to be a parenting schedule. Where you will find the differences in the discussion between a secular and a religious parenting plan is going to be centered around the timing of religious instruction, depending on the gender of the child and the distance in families. So when we're looking at what the custodial plan is going to be, we are going to consider whether or not there's going to be a remarriage that's going to take a member of the household out of the state and how that is going to affect the parenting time. We're going to consider the religious views during the marriage and any change or shift in the views or practices after the marriage. And we're going to consider the traditional roles of each parent and the ability to maintain those roles or modify those roles going forward. So while there are some similarities in the analysis, there are certainly some key differences as well. However, if you participate in the based-in and the based-in is having to make a final decision for you as to parenting time, the parenting decision must meet the secular requirements set forth under the best interest statute. It is critically important that when you work with counsel to argue at the based-in on this point, you work with someone who's experienced not only in the secular custodial arena, but also in the religious custodial arena and meeting those arbitration mandates. Part and parcel with the issue of custody and parenting time is obviously going to be support of the child or children. The support obligation in a secular case is going to be highly dependent on the income of each party. However, within the community, the income of each party may or may not be the determining factor of what is ultimately going to drive the support obligation. Within the religious community, there's other factors that will be considered, including the cost of education for the children, the long-term plan for the education, and maybe the parental or grandparent gifts that were derived for the benefit of the children. We would also likely consider whether or not there's any discounts or reductions by virtue of the divorce that might offset some of those costs and how to allocate those costs as well. The issue of child support in a religious determination is not as cut and dry as it is in a secular court. In a secular court, you will be paying weekly child support, whereas in a religious determination, you may be making direct payments on behalf of the child as opposed to direct payments to the other parent. One of the statutory factors in determining the best interest of the children is the parent's ability to agree and communicate as it relates to the children's needs. One of those needs is going to be the need to continue within the religious structure as was determined by virtue of the household commitment. So if you were in a conservative Orthodox household, the expectation is that going forward, you would continue raising the children in a conservative way. The problem comes in when two parents shift their belief as to the level of commitment or how they structure that commitment within their household. When you're dealing with co-parenting in a divorced situation, and we now have a shift in the religious upbringing, it is traditional that the based-in would look towards the continuation of the upbringing of the child and may sometimes communicate with the child's school in order to foster and facilitate the maybe less religious parent to bring standards back into the home that can meet those prior requirements. So it is important when you're looking at modification of parenting time, when you're looking at how to decide parenting time, when you're looking at days of the week and hours on the clock, that you look truly at whether or not you can meet the religious mandates that existed at the time of the marriage. And if not, perhaps build a plan that takes into consideration what you can actually provide and how you can actually provide it. If you have any questions about custody or child support, or how your case is impacted by the religious criteria set forth in the based-in, give us a call at Jersey Coast Family Law.